This is HOA Neighbor Wars. And yes, the tow truck really showed up. I am standing in my driveway in Burlington, Vermont, holding a fence panel board like proof, and Colleen Turner is screaming at me that I violated setback rules even though my permit is valid and my contractor has not driven a single screw yet. She is jabbing her finger at the panel and yelling that the association will fine me $500 today and put a lien on my house by the end of the week if I do not stop immediately. I work as a safety compliance officer, I write incident reports for a living, and I know when someone is bluffing with selective enforcement instead of actual rules. I moved to Burlington 2 years ago for the job and bought a house in Hillcrest Landing Association because the price was right and the neighborhood looked quiet. The HOA turned out to be a place where gray areas equal power grabs, and Colleen Turner, the records custodian, is the enforcer who stalls and overcharges for documents while threatening anyone who pushes back. My car is essential for my commute, and she just told me the towing threat is real if I do not comply. A neighbor complained about my planned fence yesterday, and Colleen turned it into an official violation same day, complete with surprise inspections and photo stalking the moment the contractor truck arrived this morning. She showed up 20 minutes after the contractor pulled in, clipboard already loaded with photos she must have taken from across the street. "You signed the covenants, now you live the covenants," she said, her voice loud enough that 2 neighbors came out to watch. I told her I pulled a city permit, hired a licensed contractor, and submitted the HOA architectural request form 3 weeks ago with no response. She waved the clipboard and said the board never approved it, so any work is unauthorized and subject to immediate penalties. I asked to see the denial letter. She said there was no denial, just no approval, and that means stop. I asked how I was supposed to know the timeline. She said the covenants require written approval before starting, and silence is not approval. I pointed out that the covenants also require the board to respond within 14 business days, and we were past that. She stepped closer, her voice dropping into that dangerous, quiet tone. "I can make this a lien conversation in one email," she said, and pulled out her phone like she was drafting it right there. The contractor, a guy named Miguel, who has been doing fences in Vermont for 15 years, stepped out of his truck and asked if we had a problem. Colleen immediately pivoted to him, told him he was trespassing on association property, and said she would call a tow truck if he did not leave in 5 minutes. Miguel looked at me. I told him to hold, grabbed my backpack with the camera case inside, and pulled out my phone to start recording. Colleen noticed immediately and told me recording without consent was illegal. I told her Vermont is a one-party state and I am the party consenting. She said I was harassing her and she would file a complaint with management. I said go ahead. I am documenting an HOA official threatening my contractor with false towing claims on my private driveway. She said the covenant language includes easements and the driveway access is shared infrastructure under board control. I asked her to show me that language in writing. She said she was not required to provide legal interpretation in the field, and I could request documents through the records process, which costs 50 cents per page, plus a $15 processing fee. Miguel said he was not getting in the middle of this and he would come back when it was sorted. I told him I understood, and he drove off. Colleen smiled like she had won and said the $500 fine was already in the system and I would receive a formal notice by certified mail within 48 hours. I asked what the fine was for. She said unpermitted construction activity. I said no construction happened. She said the presence of materials and a contractor constitutes activity under the enforcement guidelines. I stopped arguing and started collecting, because the end game was already set, and what she did not know was that I already had a third-party inspection report proving the property is compliant. and I was just waiting for the right moment to deploy it. I did not tell her that. I just nodded and said I would review the covenants and respond in writing. She turned and walked back toward the clubhouse, and I noticed a golf cart with a blinking amber light crawling along the street behind her, like it had been waiting. The driver was a guy in a yellow safety vest, probably another board member or a management company patrol. I took a photo of the cart, the license plate on Colleen's car parked near the mailbox cluster, and the survey stakes my contractor had placed before she showed up. I also took a wide shot of my driveway showing no construction activity, just materials staged on my property. Then I called my notary friend, a woman named Diane, who helps me organize sworn statements for work audits, and told her I needed her to witness something in the next few days. She said she was free and asked what I was dealing with. I gave her the short version. She laughed and said HOAs are worse than most employers when it comes to selective enforcement. That afternoon, I went to the Hillcrest Landing Clubhouse to request the board meeting minutes for the last 6 months and a copy of the enforcement guidelines Colleen referenced. The clubhouse door was locked, so I called the management company number on the sign. A receptionist told me records requests had to be submitted in writing, and Colleen Turner was the custodian who handled them. I asked for Colleen's email. The receptionist said email requests were not accepted, only postal mail or in-person drop-off during office hours. I asked what the office hours were. She said Tuesdays and Thursdays, 2 to 4 in the afternoon. I said it was Thursday at 3. She said Colleen was out on property inspections and would not be back today. I asked if I could leave the request in a Dropbox. She said there was no Dropbox and I needed to hand it directly to Colleen. I thanked her and hung up, then drafted a records request on my phone and printed it at the FedEx down the street. I included a list of 12 specific document types, including enforcement logs, architectural approval records, board meeting minutes, and any correspondence related to my address. The next day, I drove back to the clubhouse during office hours with the printed request and $20 in cash for fees. Colleen was sitting at a folding table inside, sorting papers. I handed her the request and the cash. She read it slowly, then looked up and said the fee estimate for this request was $132 because it included multiple years of minutes and enforcement logs. I said the covenant section on records access capped fees at 50 cents per page, plus a flat processing fee. She said the board amended the fee structure last year, and the new schedule allowed for research time at $40 per hour. I asked to see the amendment. She said it was in the board minutes, which I was requesting, so I would see it when I paid the full fee. I asked if she was seriously charging me to see the rule that justified the charge. She said the fee structure was approved and recorded, and if I did not like it, I could file a complaint with the state, but the request would not be processed until I paid. I paid the $132 and got a handwritten receipt with no itemization, just the total and Colleen's initials. She said the documents would be ready in 10 business days. I said the covenants required a 5-day turnaround. She said that was the old standard and the amended schedule allowed 10 days for requests over 50 pages. I asked how she knew it was over 50 pages before pulling the documents. She did not answer, just filed my receipt in a binder and told me I could pick up the records on the 15th. I left and immediately called Diane. She said it sounded like a stall tactic and recommended I file a state records complaint as a parallel track. I told her I would, but I wanted to see what Colleen produced first because I suspected she would either withhold key documents or overcharge again at pickup. If you are enjoying this HOA chaos, hit that like button and subscribe for more stories where Karens get hoisted by their own rules. That weekend, I got the certified letter Colleen promised. It was a formal violation notice on Hillcrest Landing Association letterhead, stating I had engaged in unpermitted construction activity on October 10th and was fined $500, due within 30 days. If I did not pay, the The fine would increase by $50 per week and could result in a lien. The notice also said I was prohibited from any further construction activity until I received written architectural approval from the board. I scanned the letter and added it to a folder I was building. Then I checked my email and found a message from Miguel, my contractor. He said he got a call from someone claiming to be with Hillcrest Landing Management, warning him that the association had flagged my property for code violations and any work he did could result in liability for him. He said he was not comfortable moving forward until I had something in writing clearing the project. I called him and explained that the HOA was bluffing and the city permit was valid. He said he believed me, but he could not risk his license over an HOA fight, and he was going to pause until I resolved it. I spent Sunday drafting a formal response to the violation notice, citing the city permit, the architectural request I submitted, the 14-day response requirement in the covenants, and the fact that no construction had occurred. I also requested an immediate hearing under the dispute resolution section of the covenants, which required the board to schedule one within 10 days of a written request. I mailed the response on Monday and emailed a copy to the management company, even though they said they did not accept email requests. I figured it created a timestamp. On Tuesday, I got a call from a blocked number. I answered, and it was Colleen. She said my response was received and the board would review it at the next meeting, which was scheduled for November 3rd, 3 weeks away. I said the covenants required a hearing within 10 days. She said the board met monthly and could not call a special session for every complaint. I said the covenants did not say monthly meetings were optional. They said disputes required a hearing within 10 days. She said I was misinterpreting the language, and if I wanted a legal opinion, I should hire a lawyer. Then she hung up. I called Diane and told her the board was stalling. She said I should show up at the clubhouse on the night of the next board meeting and demand to be heard under the open meeting rules. I checked the covenant section on meetings and found a clause requiring the board to allow owner comments at regular meetings, but it also said the board could limit comment time to 3 minutes per owner. I figured 3 minutes was enough to drop the hammer if I had my evidence ready. On October 15th, I went back to the clubhouse to pick up the records I had requested. Colleen handed me a manila folder with about 30 pages inside. I asked where the rest of the documents were. She said this was everything responsive to my request. I flipped through the stack and saw it was mostly blank forms and a few board minutes from 2 years ago, none of which related to my property or the enforcement guidelines. I asked where the enforcement logs were. She said the association did not maintain enforcement logs in a separate document. They were recorded in the board minutes. I said the minutes in the folder did not mention enforcement. She said that was because there was no enforcement activity in those months. I asked for the minutes from the last 6 months, which I had specifically requested. She said those were still being compiled and would require an additional fee of $60 for research time. I told her I already paid for the full request. She said the initial fee covered the search, and the additional documents required transcription from handwritten notes. I said the covenants required the board to keep typed minutes. She said the board kept handwritten notes and transcribed them as needed, and transcription was billable. I asked to see the handwritten notes. She said original notes were not available for public review due to preservation concerns. I said I wanted a refund. She said fees were non-refundable once research began. I asked for a receipt showing what documents were provided. She printed a one-line receipt that said records request fulfilled, October 15, 30 pages, and handed it to me. I took the folder and the receipt and left, knowing this was exactly the kind of selective enforcement pattern I needed to document. On October 20th, I filed a formal records complaint with the Vermont Secretary of State, attaching copies of my request, my payment receipts, the inadequate response, and the demand for additional fees. I also attached the violation notice in my response, noting that the board had failed to schedule a hearing. The complaint form asked if I had attempted resolution with the association. I wrote yes, and explained that the records custodian was also the person enforcing the violation and had a financial interest in stalling my access to the rules. I sent the complaint by certified mail and kept a copy. 2 days later, I got a call from a man who identified himself as the attorney for Hillcrest Landing Association. He said his name was Richard, and he was calling to discuss my records complaint and violation dispute. I asked if he was calling on behalf of the board or the management company. He said both. They were represented by the same firm. I said that sounded like a conflict of interest. He said it was standard practice, and he was trying to resolve this before it escalated further. I told him I was happy to resolve it if the board dropped the fine, provided the records I requested, and approved my architectural request. He said the board was willing to waive the fine if I agreed to withdraw the records complaint and submit a revised architectural request with a detailed survey and engineering review. I said I already had a survey, and the city permit included an engineering stamp. He said the HOA had different requirements and the board needed an independent review. I asked who would pay for that. He said the owner was responsible for compliance costs. I said the covenants did not require an engineering review for a standard fence. He said the board had discretion to require additional documentation when a project raised concerns. I asked what concerns. He said the neighbor complaint mentioned drainage and sightline impacts. I said the city permit process already addressed drainage and there was no sightline issue because the fence was on my property line, not blocking a road or easement. He said he would relay my position to the board, but he could not guarantee they would approve the project without the additional review. I asked if he had seen the third-party inspection report I mentioned in my written response. He paused and said he had not seen any inspection report in the file. I said I submitted it with my architectural request. He said he would check the file and call me back. He did not call back. On October 25th, I got an email from the management company saying the board had reviewed my hearing request and scheduled a session for November 7th at 7 in the evening, location to be announced. I replied asking for the location. No response. On November 1st, I called the management company and asked again. The receptionist said the meeting location would be posted on the clubhouse door 24 hours in advance. I said that was not reasonable notice. She said it was association policy. I said I wanted the attorney's contact information so I could follow up on our call. She said she could not give out attorney contact information and I should direct all inquiries to Colleen Turner. On November 5th, 2 days before the hearing, I drove to the clubhouse and found a printed notice taped to the door. It said the board meeting would be held at the clubhouse on November 7th at 7, and owner comments would be limited to 3 minutes per person, with sign-up required by November 6th at 5. I took a photo of the notice and emailed the management company asking how to sign up. No response. I called and got voicemail. I left a message saying I wanted to sign up for owner comments and I would be at the clubhouse the next day to do it in person if I did not hear back. On November 6th at 4:30, I drove to the clubhouse. The door was locked and there was no sign of anyone. I knocked, waited, knocked again. Nothing. I called the management company and got the same receptionist. I told her I was at the clubhouse trying to sign up for comments and no one was there. She said Colleen's office hours were Tuesday and Thursday only. I said the deadline was today and today was Wednesday. She said I should have planned ahead. I asked if I could sign up over the phone. She said no. Sign up had to be in person or in writing delivered to Colleen. I asked for Colleen's mailing address. She gave me a P.O. box. I said there was no way to get a letter to a P.O. box by 5 today. She said that was unfortunate and I should try to attend the next meeting. I called Diane and told her the board was blocking me from the hearing. She said I should show up anyway and demand to be heard under the open meeting law. I said I would, but I wanted a witness in case they tried to shut me down. She said she would come. On November 7th at 6:45, Diane and I arrived at the clubhouse. The parking lot was full, and there were about 20 people inside, most of them sitting in folding chairs facing a long table where 5 board members were setting up. Colleen was at the far end of the table shuffling papers. I recognized 2 of the other board members from the neighborhood but did not know their names. Diane and I sat in the back row. At 7, the board president, a man in his 60s wearing a polo shirt, called the meeting to order and said they would start with the consent agenda. He rattled off a list of approvals for landscaping changes, paint colors, and mailbox replacements. Then he said they would move to owner comments and called the first name on the list. A woman stood up and talked about a speeding problem on the east side of the neighborhood. The president thanked her and called the next name. This went on for about 15 minutes, and my name was never called. When the comment period ended, I stood up and said I had submitted a hearing request and I was not on the list. The president looked at Colleen. She said I had not signed up by the deadline. I said the clubhouse was locked during office hours and I was blocked from signing up. She said office hours were clearly posted. I said they were posted as Tuesday and Thursday and the deadline was Wednesday. She said I should have mailed my request in advance. I said I tried and the timeline did not allow it. The president said the board could not accommodate last-minute requests and I would have to wait for the next meeting. I said the covenants required a hearing within 10 days of my written request, and we were past that. He said the board met monthly and that was the schedule. I said that did not override the covenant requirement. He said if I had a legal issue I should consult an attorney. I said I was consulting the governing documents right now and the board was in violation. Colleen leaned forward and said I was disrupting the meeting, and if I did not sit down I would be asked to leave. Diane stood up and said she was a notary and a witness, and she wanted to note for the record that the owner had been denied his right to a hearing under the governing documents. The president said the meeting was not a legal proceeding and there was no record. Diane said she was creating one and she would be happy to provide a sworn statement if this went to court. The room got quiet. The president looked at Colleen, then at the other board members. One of them, a woman in a gray sweater, said maybe they should let him speak for 3 minutes just to avoid a problem. The president sighed and said, "Fine. 3 minutes. Starting now." I pulled out my phone and opened the Notes app where I had outlined my points. I said my name and address, stated that I had submitted an architectural request on September 18th for a fence that complied with city code and the association setback rules, and had received no response within the required 14 days. I said I was then issued a violation notice and fined for construction activity that never occurred, and I was demanding the fine be waived and the architectural request approved. Colleen interrupted and said the board never received an architectural request from me. I said I submitted it by email to the management company on September 18th, and I had a copy of the sent message with a timestamp. She said email submissions were not valid. I said the covenant section on architectural requests did not specify a submission method, only that requests had to be in writing. She said the board policy required physical submission. I asked to see the board policy. She said it was in the procedures manual, which was not a public document. I said if it was not public, it was not enforceable. The president said my time was almost up and I needed to wrap up. I said I had one more point. I pulled out a printed copy of the third-party inspection report I had commissioned 2 weeks before the contractor was scheduled to start. The report was from a licensed surveyor and included photos, measurements, and a compliance statement, showing that the proposed fence met all setback, height, and material requirements under both city code and the HOA covenants. I held it up and said this report proves the project is compliant, and I was prepared to provide a copy to the board tonight. Colleen said the board did not accept third-party reports that were not pre-approved. I said the covenants did not require pre-approval of compliance documentation. The president said the board would take the report under advisement and respond in writing. I said that was fine, but I also wanted to address the records request issue. I said I had paid $132 for documents and received 30 pages of irrelevant material, and when I requested the missing documents, I was told I had to pay another $60. I said this was a pattern of selective enforcement and obstruction, and I had filed a formal complaint with the state. Colleen's face went red. She said I was making false accusations and she had provided everything I requested. I said I had the receipts and the incomplete file, and I would be happy to show them to the state investigator when they contacted the association. The president said my time was up, and the board would take everything under advisement. I sat down and Diane whispered that I had just dropped a bomb. The board moved on to the next agenda item, which was a proposal to increase the annual assessment by $50 to cover landscaping costs. The discussion was tense, and several owners complained. The board tabled the vote and moved to close the meeting. Before they could adjourn, Diane stood up and said she had a question about the enforcement guidelines. The president said the comment period was over. Diane said she was not making a comment. She was asking a procedural question, and the open meeting law allowed questions. The president reluctantly said go ahead. Diane asked if the board maintained a log of all enforcement actions, including fines, warnings, and violations. Colleen said enforcement records were kept in the board minutes. Diane asked if the minutes included the name of the person who initiated each enforcement action. Colleen said that was confidential. Diane said the covenant section on enforcement required transparency and equal application of rules. And if the board was not tracking who initiated complaints, there was no way to ensure the rules were being applied fairly. The president said the board did not have to answer hypothetical questions. Diane said it was not hypothetical, it was directly related to the owner's case. Because the violation notice did not identify who made the complaint or what rule was violated. She said if the board was going to fine owners, they had a right to know the basis for the fine and who triggered it. The woman in the gray sweater said Diane had a point, and maybe they should review the enforcement process. Colleen said the process was fine and this was just an attempt to intimidate the board. The president said the board would discuss it in executive session and adjourned the meeting. As people filed out, Colleen walked past me and said I should be careful about filing complaints because the board had the authority to fine owners for frivolous actions. I said that sounded like retaliation and I would be documenting it. She did not respond, just kept walking. The next morning, I got a call from Richard, the attorney. He said the board had reviewed my submission and they were willing to approve the fence project if I agreed to 3 conditions. First, I had to withdraw the state records complaint. Second, I had to pay the $500 fine. Third, I had to sign a waiver acknowledging that future violations could result in immediate lien action without a hearing. I said no to all 3. He said the board was trying to be reasonable. I said the board was trying to cover up selective enforcement and I was not going to help them. He said if I did not accept the offer, the board would proceed with the lien process and I would be responsible for all legal fees. I said I would see him in court, and I hung up. That afternoon, I got an email from the management company saying the HOA had hired a vendor to remove the fence materials from my driveway and bill me for cleanup costs. I called Miguel and told him to get his materials out immediately. He said he was already on the way because someone from the HOA had called him and said the project was canceled. I told him it was not canceled, the HOA was just trying to sabotage it. He said he would pick up the materials, but he was not coming back until this was resolved. I understood. I also called Diane and told her the HOA was escalating. She said it sounded like they were panicking because the records complaint was real, and they knew it. She suggested I contact the state investigator directly and provide an update. I did, and the investigator said they had received my complaint and were reviewing it, but it could take 60 days to complete the investigation. I said I did not have 60 days because the HOA was threatening a lien. The investigator said I should consult an attorney if I needed immediate relief. I called a lawyer I knew from work, a guy named Tom who did property disputes. I explained the situation, and he said it sounded like a classic HOA shakedown. He said the third-party inspection report was solid evidence and I should use it to pressure the board into settling. I asked how. He said I should send a formal demand letter threatening a lawsuit for breach of covenant, selective enforcement, and retaliatory fines, and attach the inspection report as proof that the board had no legitimate basis for the violation. He said most HOA boards folded when they realized the owner had documentation because their insurance did not cover bad faith enforcement. I asked what it would cost. He said he would draft the letter for $500, and if it went to court, we would talk about a retainer. I agreed. Tom sent the demand letter on November 10th. It was 3 pages, and it cited every covenant violation the board had committed, including the failure to respond to my architectural request, the improper fine, the denial of a timely hearing, and the obstruction of my records request. It also included a paragraph about Colleen's conflict of interest as both records custodian and enforcement officer, and it noted that her statement about making this a lien conversation could be interpreted as extortion. The letter demanded that the board immediately rescind the fine, approve the architectural request, provide all requested records at no additional charge, and agree in writing not to retaliate. It gave them 10 days to respond. On November 15th, I got a call from Richard. He said the board had received the demand letter and they wanted to schedule a settlement conference. I said I was open to that if the board was serious about resolving this. He said they were, and he would send me a proposed agenda. The agenda arrived by email that afternoon. It proposed a meeting on November 20th at the clubhouse with me, the board president, Colleen, Richard, and a mediator from the management company. I replied and said I would attend, but I wanted Diane present as my witness. Richard said that was fine. On November 20th, I arrived at the clubhouse with Diane and the inspection report. The board president and Colleen were already there, along with Richard and a woman from the management company who introduced herself as the mediator. We sat down at the long table, and the mediator said the goal was to find a resolution that worked for everyone. I said my goal was to get the fine dropped, the architectural request approved, and the records provided. The board president said the board was willing to drop the fine if I withdrew the state complaint and the demand letter. I said I would withdraw the demand letter if the board approved the project and provided the records, but I was not withdrawing the state complaint, because that was about a systemic problem, not just my case. Colleen said the state complaint was based on false allegations, and if I did not withdraw it, the board would countersue for defamation. I said that was ridiculous, and I had documentation proving every claim in the complaint. Richard said everyone should take a breath and focus on the immediate issue. He said the board was willing to approve the fence project if I agreed to use the survey and inspection report I had provided, and if I signed an acknowledgement that the approval was specific to this project and did not set a precedent for future requests. I said that was fine. He said the board was also willing to provide the requested records, but they wanted to clarify the scope so there was no dispute about what was included. I handed him a list of the 12 document types I had requested. He looked at it and said some of these were not public records under Vermont law. I said the covenant section on records access did not limit requests to public records. It required the board to provide any document related to association governance. He said he would need to research that. The mediator suggested we take a break. During the break, Diane pulled me aside and said the board was stalling because they did not want to produce the enforcement logs. She said those logs would show that Colleen had been selectively enforcing rules against people who challenged the board, and that was the real issue. I agreed. When we reconvened, I said I would agree to approve the fence and drop the fine issue if the board provided the enforcement logs and agreed to a third-party audit of the records process. Richard said the board was not going to agree to an audit. I said then we did not have a deal. The board president said I was being unreasonable. I said I was being transparent, and if the board had nothing to hide, they should welcome an audit. Colleen said I was trying to weaponize the process. I said I was trying to fix a broken process, and if she had been doing her job properly, we would not be here. The mediator said it seemed like we were at an impasse. Richard said he had one more proposal. He said the board would approve the fence, drop the fine, provide the records on my list except for the enforcement logs, and agree to a policy review by the management company. In exchange, I would withdraw the demand letter and agree not to file any further complaints about this specific issue. I said I wanted the enforcement logs. He said the board considered those confidential personnel records. I said enforcement logs were not personnel records, they were governance records. He said the board disagreed. I said fine, I would let the state investigator decide. Richard looked at the board president and Colleen. The president said they needed to caucus. They stepped outside for 10 minutes. When they came back, Richard said the board had a final offer. They would approve the fence, drop the fine, provide all the records including the enforcement logs, and agree to add a written no retaliation policy to the covenants. In exchange, I would withdraw the demand letter, and they would issue a formal apology for the record's delay. I looked at Diane. She nodded. I said deal. Richard drafted a settlement agreement on the spot. It was 2 pages, and it included every term we had discussed, plus a clause requiring the board to refund the $132 I had paid for records, and the $500 fine that had been assessed but not yet paid. I read it twice, signed it, and Diane notarized it. The board president and Colleen signed as well. Richard said he would file the agreement with the association records and send me a copy. I thanked him and walked out. As I was leaving, I heard Colleen say something to the president about how this was going to set a bad precedent. I did not care. I had won. 2 days later, I got a call from Miguel. He said he heard the project was approved and he was ready to start. I told him to come by whenever he was free. He showed up the next morning with his crew, and they finished the fence in 2 days. It looked great. The day after the fence was done, I got a package from the management company. It was a binder with all the records I had requested, including 6 months of enforcement logs. I spent an evening going through them, and what I found was exactly what Diane had predicted. Colleen had initiated 17 enforcement actions in the last 6 months, and 15 of them were against owners who had filed complaints or challenged board decisions. 2 of the actions were against owners who had requested records. The pattern was clear, and it was documented. I called the state investigator and told her I had new evidence. She said the investigation was still open and she would include it in her review. A week later, I got a call from Richard. He said the state had contacted the association and requested a full audit of the records process. He said the board was cooperating and they had hired an independent auditor. He also said Colleen had resigned as records custodian, effective immediately. I asked why. He said she cited personal reasons, but he suspected it was because the audit was going to expose the selective enforcement pattern and she did not want to be there when it happened. I said that was probably smart. He said the board wanted to thank me for bringing the issue to their attention and they were committed to cleaning up the process. I said I appreciated that, and I hoped the new policy would actually be enforced. A month later, the audit report was released. It found that the association had violated state records laws in multiple instances, including charging excessive fees, withholding documents, and failing to maintain proper logs. It also found that the enforcement process lacked transparency and had been applied inconsistently. The report recommended 12 specific changes, including a cap on records fees, a requirement that all enforcement actions be logged with the name of the complainant, and a prohibition on board members serving as records custodian if they were involved in enforcement. The board adopted all 12 recommendations and issued a formal apology to the membership. Colleen's selective enforcement was documented in the minutes, and the compliance process was audited and cleaned up. I ran into Colleen at the mailbox cluster a few weeks later. She did not say anything, just grabbed her mail and walked away. I did not chase her. I had made my point. The fence was up, the fine was gone, the records were public, and the board had a new policy that actually protected owners instead of punishing them. That was enough. Thanks for watching, and I will catch you in the next one.